Hello, I'm Dr. Karen Hiltz, and I want to welcome you to another session of the Apple Report. This week we're going to talk about court cases. I think these are very interesting myself, and I hope you'll find them interesting as well. These are going to be some U.S. Supreme Court cases, but remember I stated previously that the U.S. Constitution is silent when it comes to education. But there are two amendments that education cases typically are decided upon. The First Amendment, which is known as the Establishment Clause, you cannot establish a religion. The 14th Amendment is the second one, and that is where due process and equal protection under the law come into play. And it's usually equal protection under the law that is discussed with regards to these court cases on education. So let's go ahead and start with the first one, which is Brown versus Board of Education out of Kansas. And it was a 1954 case, and it was dealing with desegregation of public schools. Now, this was a challenge under the Equal Protection Clause of the 14th Amendment, in that at that time there were schools for black children and there were schools for white children. And Mr. Brown said that his daughter was not getting equal protection under the law. There was disparities between the schools. And so this case was precedent setting in that it was one of the elements that started desegregation and the civil rights movement in the United States. The second one I want to talk about is Lemon versus Kurtzman, which is dealing with Pennsylvania and Rhode Island, and it's a 1971 case. And this is a case that decided that there was a three-pronged solution, or a test, and it challenges the Establishment Clause under the First Amendment. Now, what this case talked about was if the legislation can pass this test, or if the case can pass these three prongs, then it will be constitutional. The three prongs are: the statute must have a secular legislative purpose, meaning the state statute. Second, its principal or primary effect must be one that neither advances nor inhibits religion. And finally, the statute must not foster excessive entanglement with religion. The U.S. Supreme Court decided that it did violate the third prong, and so therefore this was unconstitutional. Here's an example of how the language of the legislation is important. The third piece of legislation or court case I want to mention is San Antonio Independent School District versus Rodriguez out of Texas, and this is a case from 1973. This case discussed the disparity of public funding among school districts. This is an equal protection clause under the 14th Amendment case. And what that one dealt with was taxation and how school divisions are funded via our taxes. And so therefore there was not equal protection because one school district, had higher real estate property values than the abutting school division did. And so therefore they felt that it was unequal. And the U.S. Supreme Court said this isn't really a federal issue. It's a state issue because it's dealing with state taxes. And so they passed it back to the state level for decision. The last one I want to talk about is Zellman versus Simmons-Harris, which is a Ohio case from 2002. And this one challenges the First Amendment, meaning Establishment Clause. And this is about the EdChoice scholarship program that Ohio has. Now, that program sets out an opportunity. It identifies the criteria, and it affords an opportunity for children to have a scholarship to go to a school of their choice, non-public school of their choice. Now, the court decided in favor of upholding this program because it was neutral. The language in the statutes was neutral. As long as the children qualified and met the qualifications for the program, then it was constitutional. The scholarship went for the child. It didn't go to a school. So whichever school the parents wanted the child to go to, the scholarship was legitimate and funded. Here again, another example of how legislation is written and how important the language of the legislation is. The last case I want to talk about is a case that is currently before the U.S. Supreme Court, and it is expected to be decided by June of this year, the end of June of this year. It's a case called Espinoza versus Montana Department of Revenue. And what this case is about is it's a tax credit scholarship program that Montana legislature had passed. What that program consisted of was private donations being provided for parents to choose to send their children to a private school. Now, these were donations, but the Montana Department of Revenue said, well, it's an indirect impact for using of public funds because it is money. It is, even though it's donations, it has a direct impact with regards to public funding because of the tax credit portion of the program. Anyway, that case is I'm watching because it will be very precedent setting from a Blaine Amendment state language perspective. Now, remember, we talked about before that there is Blaine Amendment language which prohibits to some degree the use of public funds for private education. So this is a very important because this could be precedent setting for changing state constitution Blaine Amendment language. So hopefully you enjoyed this conversation, this session, and I look forward to hearing from you, giving me some feedback. And next week we will talk about some of the entities that are involved and their role, both positive and negative, with regards to the education system. The positive and negative will be from my opinion, though. So anyway, enjoy and have a great week, and we'll see you next week.